So we're going to begin the presentation. Again, if you have questions, put them into the Q&A. All right. So I'm calling this the Prop 19, its devastating effects on your family. So most of this is going to be focused on the inheritance piece and then what we can do about it real quick. If any of you don't know me, I'm Janice Carney. I'm an attorney. I've been an attorney in the area of estate planning and elder law for about 30 years now. And I've been in the Los Gatos, Saratoga community for almost all of that time. Serving, of course, the entire state of California if people want to come to me. Again, we have to have a disclosure that this is an educational presentation. It does not constitute legal advice. Please seek the advice of an experienced estate planning and elder law attorney for your specific needs. What brings us here today is the impact that Prop 19 is going to have on all of us until at least it's modified by a subsequent election. Prop 19 appears to have passed, as I said, on November 3rd by, there's two parts to Prop 19. The whole name of the act is the Home Protection for Seniors and Severely Disabled Families and Victims of Wildfire and Natural Disasters Act. This actually had two parts to it that had separate names. We're going to be investigating mostly today how it's going to affect family-owned properties and what maybe some of the solutions are. Okay, so Prop 19 amends California's Constitution, Article 13A, Section 2.1, for all of you attorneys out there. We don't know where it's going to be exactly codified. I assume it'll be in the section 62 through 65 of the Revenue and Taxation Code, but we'll see where it actually ends up. Part one of the act, that was the part that most people wanted and thought that they were voting for, is actually the part that's called the Property Tax Fairness for Seniors, the Severely Disabled and Victims of Wildfire and Natural Disasters. Who wouldn't want that? This part of the act becomes effective as of April 1st of this coming year. And it essentially allows individuals to roll their Prop 13 tax base to up to 3 times anywhere in the state. This section applies to seniors, that's 55-year-olds and over, the severely disabled and victims of the wildfire and natural disasters whose personal residence was at least 50% or more destroyed. Family home, what it affects is the family homes and farms that are the principal resident of the claimant. It applies when property is purchased or complete construction of a new residence, within sale of an old residence, or within 2 years of the destruction of the property for victims of disasters. Folks can relocate in and out anywhere in the state of California. In the past, they were restricted in where they could go, but now it'll be anywhere. Why are we doing this? To allow homeowners to move and carry over to the new residence their Prop 13 tax base from the old to the new. Okay, so there's always some questions about how is this going to work. It did not allow homeowners to carry their entire tax base if they or it does allow them to carry the entire tax base, but it doesn't allow them to buy a more valuable piece of property and not have a tax adjustment. So the way it works is if you buy a property of equal or lesser value, you carry your old assessed value to the new one. If you're buying up in value, greater value than the old one, then you're going to have the tax base from your old one rolled in, and there's going to be you're going to have an addition to your to the old tax base, the difference between the fair market value between the two properties. So if you if your old property was $1.5 million and you buy a $2 million property, you're going to take your old tax base plus that $500,000 that you have increased. Now you do get no, that's on the next one, sorry. You are going to be filing an application in the county where the new one is located, and seniors and the severely disabled can do this up to 3 times. Victims of welfare can do it an unlimited number of times, but again, it's only their personal residence, and so it would be pretty awful if they continually have disasters. But if they do, then they can use it over and over again. Okay, the second part of the act, which is what we're going to focus on, is the property tax fairness for family homes. And this part becomes effective on February the 16th. However, as we're going to go through this, you're going to see that we're going to need to get the documents recorded and the claim forms submitted by this date. And since I believe February 16th is over the President's Day weekend, it'll be, I understand it'll be probably February 11th, which is our real deadline for getting our documents in. So this part basically revokes the Prop 58 parent-to-child transfer and the Prop 193 grandparent-to-grandchild transfers, except with one very limited exception, and that's for the family home. Who can take advantage of this is parents or grandparents transferring to eligible children or grandchildren. The same rules apply for defining who is a child or a grandchild as they were in Prop 58 and 193 previously. It only applies to the family home and farms that are or become the principal residence of the transferor and the transferee. In the past, we only had, with Prop 60, the one that allowed us to move our assessed value one time as a senior, it was only it had to be the transferor's home. Now it has to be the transferee's as well. The date of the transfer is the date of the lifetime, the deed that's created during lifetime or at death or on a court order or a decree. So if you have a probate and it takes a while to get a determination of distribution, I think that that's what they're talking about there on court order and decree. Otherwise, basically, it's going to be the date of death or the date of the deed that transfers. That's the date of the transfer. It allows homeowners to transfer a limited amount of their Prop 13 tax base value on their principal and their current principal residence to eligible children and grandchildren to use as their personal residence, thus the family home concept. You will be doing this with forms that are to be promulgated, I'm assuming, and the transferee, it's noted that the transferee who is going to be using it as their home has to file a homeowner's exclusion within 1 year of the transfer. The benefit limit, you can only transfer your current assessed value plus up to $1 million of additional value. So how this works is that if the property that you're giving is has not appreciated more than $1 million over its tax assessed value, then the new buyer will, or the new owner, the child or grandchild, will have the assessed value that the transferor had. If the property has gone up, then it will be increased. I've got a couple of examples on the next screen. I'm not going to go over everything after this in as detail. I don't want to be reading the screens, but I have made these slides so that you can get them from us after the program and have them as a reference. So again, here's two examples, one where the assessed value did not go up, and one where the assessed value did go up because the property was of greater value. I'll leave that for you to look at on your own. Okay, so we need to look now at comparing the rules for all of the transfers. I'm going to compare both before, what happens both before, on or before, versus after February 15th if we transfer the property before or after those dates. I apologize, I'm not very good at just clicking this one time. Okay, all other transfers will result in reassessment. So it's only that limited family home that you'll be able to basically carry the assessed value to the family, as we have been able to do for under Prop 58 and Prop 193 for several decades now. So what are the other kinds of properties? It might be a home where the child is not going to live, or it could be a home, other homes that you own, where maybe the children do live, but you don't live there. So remember, on the family home, both it has to be you, the transferors, and the transferee's personal residence. It could be vacation homes. Those are not do not count as of course, the primary personal residence. It can be rental property or commercial property. All of these things are going to be affected by this proposition on the transfer. I'm going to start with other homes. And a lot of the examples I have are coming out of cases that I've had over the years. This particular mom is going to have a problem because she owns 3 homes and she has 3 children. They all occupy one of the homes, and she bought them because she is very fervent about wanting to make sure that her kids have a home and that she can leave to them. So they're each occupying one of the homes. One was an inherited property that she got from her parents, and it has a very low assessed value, about $75,000. One of her kids, who's a single guy, lives in there. It happens to be right close to the Google campus, so its fair market value has skyrocketed, even though it's not all that big of a property. And its current fair market value, which I'm using fair market as the an approximation of what the new assessed value would be if the property would be reassessed. So it's probably about $2 million. The property taxes are about $900,000 currently. That property, there will be no exclusion if mom transfers it to her son after February 16th, because, or on or after February 16th, because it is not the family home. Mom doesn't occupy it. If the property is transferred with, let's say, right after February 16th with the current fair market value, the reassessment is going to go to about $2 million. Property taxes are going to go to about $24,000. I used 1.2% as the property tax rate on the assessed value. I know that Prop 13 only authorizes 1%, but then you get to have up to another percent in local additional taxes on the property, such as bonds. Okay, so I'm going to go over to home number 3, again, this is not occupied by mom. It's occupied by the 3rd child who has a spouse in that property with her. The assessed value, mom bought this home because she had the other 2 for years, but she bought this one so she could have 3 of them to give 1 to each of her children. This assessed value, she bought it for about $400,000. It's currently about $600,000 fair market. The property taxes are about $4,800. Again, there'll be no exclusion after February 15th, actually, as of February 16th, 2021. And the property tax will be reassessed if she goes ahead and gives it to her daughter sometime next year to $600,000. Property taxes are going up to $7,200. So you can see the differences between the old and the new taxes because of the transfers. The home that she currently occupies, which is in Milpitas, she occupies it with her 3rd son. Its assessed value, because she bought it long time ago herself, and it was her original home. It's about $120,000 assessed value. Current fair market value on it, though, is about $850,000. The property taxes are $1,365. This one is the perfect model of that family home that the code was excluding. So the property is not even worth more than $1 million over the current assessed value. So the property taxes are going to stay right where they are. I do want to point out that I did take off the homeowner's exemption on the home that mom is occupying. The son will continue to have that. The property tax on the other 2, the children, when they receive it, will be able to claim that homeowner's exemption for themselves. So it'll be a little bit less than the dollars I've modified there. Okay. We're going to talk about that family again when I talk about some solutions. The rental property situation, let's give a couple of examples that I've had come through my office. One is a 4-plex where mom occupies one of the units. In this situation, the assessed value is $225,000. Current value is $1.2 million. The property taxes are $2,700. Mom dies. Let's say she dies in 5 years, and the property has gone up, and she's left it to one child who actually moves into that unit that mom occupied. We're just going to have this example for right now. That family home exclusion will apply to the unit that mom occupied, which we believe will be probably 1/4 of the entire value. Not sure of that. It may be that the assessor will divide up the value based on square footage. But for our purposes, we're just going to say it was 1/4 of the property, one of the units. Again, 5 years from now, the property's gone up to $2 million in our just scenarios. Mom's property tax at that point, and as long as she's living, is about $2,900. But when she dies or gives the property to her children, the family home portion of it, because that son's going to move in, stays the value of it is 1/4 of the current assessed value. So it will be about $56,000. The rental units will get reassessed. They're as 3/4 of the current value at that time, which will be about $1.5 million. The property tax, so the total assessed value will be $1,556,000, and the property tax will go up to $18,875 roughly. So you can see how it will apply to rental unit property that is partially a home and partially rental property. Let's say this is a single family rental that mom and dad own together. They are getting income off of it. which is very common. They bought it a long time ago. Assessed value is about $200,000. Currently, it's worth about $1 million. They're only paying $2,400 a year on the property taxes. For this one, there is no exclusion after February 15th, 2021, because again, it's not the family residence. And let's assume the second parent dies. It won't be reassessed until that point. And the rental is left to, making it simple, one child. Fair market value in 10 years, let's say it's doubled in value. That's very, very possible in our area. To $2 million. Parents' property tax at that time would be $29.25. The new assessed value on the property is going to be $2 million, and the property taxes are going to shoot up to $24,000 a year. Okay. Let's say this is a vacation home. The family condo at Tahoe, or maybe the family Santa Cruz Beach House. All of the numbers just roll through. Not going to go through them in detail, but the point is that property taxes currently on the condo in Tahoe is about $2,000. We're going to pretend that these parents are a little younger, and the last of them doesn't die for 20 years. This property is probably quadrupled in the last 20 years that they've owned it. So let's assume it quadruples again. And the fair market value in 20 years is $2.4 million. Again, no exclusion applies because this is a vacation home. It's not the primary personal residence. The parents' property tax at that time would be $3,000, but it's going to go up. The property taxes are based on the $2.4 million assessed value at that time. It's going to go up to $28,000. So the question is, are the kids that are inheriting this going to be able to maintain that property? The Santa Cruz Beach House, this is one of my clients, has this property. Assessed value currently $120,000, but the property is really worth $3 million. They've owned it in the family for a long time. Property taxes are under $1,500. Last parent dies in 10 years again. We're pretending that the property a little bit more than doubles in that time. Parents' property tax, or the property tax on the property, is going to go from just over $2,000 at that point to $78,000 based on those numbers. Rental, I must have skipped the other one previously. Sorry about that. Okay, so commercial property. Let's say we have a small office building, or we have an industrial property with a couple of warehouses and maybe a small office on it. Okay, that small office building, parents have it. They depend on the income from it. They are quite elderly in this particular scenario. And so I'm assuming that maybe the last one of them dies in about 2 years. Both of them are over almost 97 years old. They have 3 children. When that property, the current fair market value of it, $7 million, let's say in a couple of years, it goes to $8 million. That property tax is going to go from $24,000 that they're paying right now on the assessed value of $2 million to $96,000 a year based on the new assessed value of $8 million. Industrial property. These people's paid about $350,000 for this investment property. The current value of it was a good buy. That is about $2.5 million. The property taxes are $4,200. If parents are in the position to sell this to their child, let's say they do it next year, but it doesn't get done before February 16th. No exclusion is going to apply, and the new property taxes are going up to $30,000. But here's a first solution. What if that sale to the child can get completed before February 15th? then this property will qualify for the current Prop 58 exclusion of up to $1 million of other than personal residence property. It's going to be able to carry over in the current assessed value of $350,000, and the property taxes will remain at $4,200. Big difference between $4,200 and $30,000. Parents might also, you might say, well, that's going to mean a property tax, not property tax, but capital gain to the parents. Well, maybe they could use a 1031 exchange to defer that capital gain, because this is not the residential property, their residence. Okay, so what do we do about all of these taxes going up? There are several rules we can apply. The rules that do not go away are the spousal exclusions. This also applies to registered domestic partners, and basically says if you transfer it to a spouse, then there's no change of ownership, which triggers the reassessment. You might be able to also use the joint tenancy original transfer or exclusion. I'm going to talk about that in a minute. Or you might use an entity. Another tool we're going to use are outright gifts or outright sales or transfers, and then also irrevocable trusts. But these ones that I've listed have exclusions right in the code for property taxes. I remember we're talking about the other, what can we do right away to take advantage of the situation that we have, this sort of twilight period, I've heard it called, between now and when the law takes effect on February 16th. And we're going to go using that twilight period to see what we can do. Okay, so we've got transfer problems and solutions. Okay, I do apologize for this. I don't know, maybe if I use my buttons on the keyboard, it'll be easier. Okay, so we're going to assume all of these transfers happen before February 16th. And again, that's really before, so that we get them recorded, maybe get the claim forms in. We don't know what all of those rules are going to be, but to be safe that we get everything recorded and filed and submitted before the President's Day holiday, which will probably mean that February 11th is our last day to do that. One of the problems that I will point out later is that because of COVID, it's taken longer to get property processed through the assessor and the recorder's office. It's also likely to be a flood of documents coming in with from people who are wanting to take advantage of the exclusions to transfer properties ahead of time. So one of my colleagues has said that he's basically going to say they're you know, as of February 1st, that's the sort of their artificial cutoff. I'm not sure what the best thing to do is there, but you have to keep that in mind as another problem. Okay, in this scenario, we're going to have the highly appreciated rental property where the child resides and pays rent to mom. The current assessed value is $100,000. Fair market value is $1 million. The problems in this is that the child needs to keep parents' assessed value to remain in the home. They will not be able to stay in this area if that assessed value goes up. The transfer at the parent's death will result in a reassessment to the then current fair market value because it does not qualify for the family home exclusion. The parent does not live in the property, only the child lives there. The parent needs the rental income for support that the daughter's paying She also wants her child to continue to pay rent. It's healthy for that relationship for the child to have that kind of responsibility. So what do I think we can do here? I think there might be two solutions that I would recommend in this case. Remember, we want to keep the rent for the parent coming in. We could use a long-term lease. This, I'm just assuming that maybe we'll do a 100-year lease. Anything over 35 years is supposed to be acceptable. That lease will trigger a change of ownership at the time of the lease takes effect. And that is a change of ownership that I believe we can claim a Prop 58 exclusion, because the lessee, who will be the child, is the, it will be a parent to child transfer, parent being the lessor and child being the lessee. The child would then continue to pay rent to the parent, which is needed in this case. And if the parent then leaves the property, the fee interest in it, for attorneys know that, that means the full ownership of the property to the child at the parent's death. That will result in a merging of that fee and leasehold interests, and there'll be no change of ownership. Also, because the fee interest is in the parent's estate, they will get a step up in basis on that property for capital gains purposes. A scenario two, or solution two, let's assume we don't have a long-term lease. I understand that there is some issues about, because the child is living in the property, whether it would be deemed long-term, but regardless whether it is or not, when the property parent then transfers the property into the irrevocable trust, that's going to trigger a change of ownership, because the child is going to be a present beneficiary. The parent could stay a beneficiary of this trust as well. There would be no change of ownership if the parent was the only present beneficiary, but because the child is also, it does trigger the change of ownership. But this is a change of ownership where you can file a claim for the Prop 58 exclusion on the property. Let's assume that this trust allows the trustee to sprinkle income to parent or child, and I didn't put child there, but sprinkle income to parent or child, and the trustee actually sprinkles it to the parent, so the parent gets the income that the child is continuing to pay to the trust for the rent. The trust then terminates on the earlier of parent's or child's death. If the child tragically dies first, then it goes back to the parent. That's a rescission. And so the, or not rescission, reversion to the parent, and the parent was the owner, so there's no property change of ownership at that point. If instead, as would be expected, the parent dies first, then the resulting the property will pass to the child. Because the child had a present interest, this transfer, the termination, is not held to be a change of ownership under the property tax rules. So the child, their lifetime interest and their remainder interest merge, and now they have the property, and it's not reassessed at the parent's death. So now I would throw into this trust a general power of appointment. That's what GPOA is for non-attorneys out there. And for the parent to be able to change the beneficiary of the trust on the parent's death, probably to the creditors of the estate, to get the stepped up basis. You might also put in a testamentary special power of appointment if there's some reason you don't want the general in there. However, there is questions about, do you get a full step up if it's a testamentary special power? Okay, transfers. Again, here's that 3 houses, 3 children scenario that I talked about earlier. My clients, again, reminding you, child 1 occupies the first house alone. The assessed value, you can see all of those numbers there. The second property was the home where mom lived with the another child. Property tax in that case is $1,365, and the third one is occupied by the third child and the child's spouse. Property tax is currently $4,800. Here are the problems, besides, of course, reassessment. There's no exclusion for 2 of the homes passing to the children. And there is, of course, a desire to have the date of death step up on all 3 properties. I'm using in this case, or I'm suggesting in this case, that we might use the joint tenancy original transfer or exclusion from property taxes. So if, again, these are transfers before February 15th or by February 15th. The first house, if mom gives half of it of the house to the child number 1, they take title as tenants in common. The claim is then made for half of that house. Remember, the assessed value is only $75,000 on that, so it easily falls under the $1 million exclusion of other than the personal residence transfers. The child and the mom then transfer that home from tenants in common to themselves as joint tenants. Then they become what is called under the, for property tax purposes, original transferors. There's no change of ownership on that transfer because it was just a difference in the way they held title. Mom then, of course, dies at some point. The property passes to that child and no change of ownership occurs as child 1. Again, this is where that original transferor is important, was an original transferor, and because they were there, they get the property and there's no change of ownership. The entire property gets a step up at mom's death as all the joint tenant interests originated from her. So under the Internal Revenue Code 2040, this is where we're going to get the full step up. Let's do house 3. She does the same thing, ditto, but in this case, there is the child has a spouse. So it might be a little different. We do the same thing into tenants in common, claim fill out the claim form. The house then gets put into deeded to joint tenancy, no change of ownership. Mom and child could transfer to themselves plus the child 3's spouse, all as joint tenants. That spouse that then becomes another or a third original transferor. And remember, that's an important distinction along with mom and child 3. Then again, mom dies, the property passes to child 3, or if they've added the spouse, to the child and the spouse. There's no change of ownership. Again, the property is entitled totally in mom's estate for estate tax purposes, which means that you get a step up in basis on the entire property. Oh, Jen, I remember to use my buttons instead. Okay, now how about commercial and rental properties? So in this case, let's use that small office building that we had before, or maybe mom and dad own several rental properties. Family desire to keep the properties to produce income for family and for future appreciation for the kids. Remember, current property taxes are $24,000 on it, assessed value is $2 million. Again, in these scenarios, I've got very elderly owners. There's property taxes going to have a huge increase at the last parent's death. I think that went from 24,000 to 78,000 in my example that I had before. They would like a step up in basis to avoid cap gain if they must sell it. That's a harder thing to keep. This isn't really a capital gains or income tax program. I'm focusing on property taxes. So there may be some give and take on some of the cap gain versus property tax. But the children really would like to keep the properties for income tax purposes after mom and dad pass. Here I'm going to use an entity. There's some entity exceptions in the code for property tax. Again, we're going to combine this with immediate transfers as well. So in this case, would recommend that parents transfer half of their property to the children. Remember, there's 3 children, so each is going to get a third of a half, which means a sixth, to each of the 3 children. They're going to immediately make the claim for the Prop 58 exclusion. Remember, the current assessed value of the property is $1 million. So there is $2 million, so half of it is going to use up that entire $1 million of exclusion on the transfer of non-personal residence property. Assuming that they haven't made previous transfers, we're all good there. If they have made prior transfers, then we may reduce the amount that we transfer to the kids at this point. But this would be the perfect thing to do, is to give the children right off the bat half of the property. Then the parents and the children create an LLC, limited liability company, into which they all transfer all of their interests. Parents each, remember, they together have 50%, they each have 25%. Each of the children have 16.66% interest. So there's no change of ownership when they create it and they put the house into this LLC, because it's called a proportional transfer. The interest before and the interest after transferring it into the LLC are identical. So no one is deemed to have control of this particular LLC. Control is considered for property tax purposes, to have over 50% of the value of the entity. So in this case, no one has 51%, so no one really has control. The parents then leave their 50% to the 3 children in equal shares. Each child is now going to have 1/3. Again, 33%. No one has over that 50% mark. So there's no change in control. A change in control is important, because if you have a change in control, the whole property inside gets reassessed, or is deemed to have changed ownership and gets reassessed. So, and new property tax. So it's important to note this. Also, because these are original owners of the property, they put it all in, we have to keep the cumulative transfers to not more than 50%, which is perfect. Parents own 50%, they transfer their 50%. There's no trigger of the for change of ownership on that basis either. So the income then on the property continues to be paid out to the family in proportion to their percentage shares, at least in the LLC that I've envisioned. It could be differently done depending on how the LLC is structured, but we're not going there. Okay, here's some other challenges. As I said, there is a loss, a potential that we can't get this done by February 15th. COVID effect on recording is going to slow things down. There might be some income tax consequences if parents sell that property that investment property to the son, and they're now recognizing capital gain on some of it. We're going to have to look at what can we do to minimize those, but that's a different program. In some cases, parents are going to lose control or even the use of the property. So, you know, how is that going to affect the whole family? If that mother signs a lease with her daughter for the house, is she, and it's a very long-term transfer, the lessee has most of the powers over that property, and is mom going to have the control she would like to have over it, even though she continues to get rent? There may be some transfers or changes in deductions depending on who gets the properties and what interests they have. There may be, again, a loss of step up in basis for capital gains. Again, these are all additional issues to work out on a case-by-case basis. No one answer will suit everyone. So we have to figure out what the plan is. We're trying to solve as many problems as we can. Again, every case is going to be different. We're going to use some trusts. We're going to use maybe some leases. We're going to use outright transfers, maybe entities, joint tenancies with that original transfer or base exclusion. These are some of the things that we need to do. Remember, we've got to get it done. If we're going to use any of those techniques that involve some transfers now to the children to bring them on title in one way or another, we have to get it done before February 15th, probably before February 11th. And so there's not a lot of time left. Our firm, you know, we would be able to work with folks on this. I want to say that if you're listening to this and you're not one of our current clients, you need to potentially talk to your existing estate planning attorney to go over some of these aspects. If you would like to have a consultation with me about what my ideas are so that you might take them to your attorney, you can do that. We are offering a very, very quick 15-minute consultation for free, just to see, you know, how things are, what kind of situation you're in, and should we talk about it in full, and should I look over all your documents? If you then want to, and you don't have to have the 15-minute free consultation, you can go directly to my 45-minute consultation. I charge for that. It'll be $450. Paid in advance. You will sign a retainer agreement only for that consultation with no obligations beyond that. I'm actually devoting an hour to that because I'm going to look over the documents that I want you to provide to me ahead of time, and then I need to make some notes afterwards. If at the end of that consultation you then desire us to effectuate that plan, if we come to it, then we'll probably set you up for a design meeting and talk about at which time we would refine the documents that we're going to use and the terms that are going to be in it. But if you go back to your attorney, at least after that 45 minutes consultation, hopefully you'll have some ideas to talk over with your attorney. If your attorney wants to be on that call with you, that's perfectly fine with me. So, you know, I just don't want folks to not have an opportunity to chat with me if they want to. I'm not the most expert attorney in the state on property tax by a long shot. So there are other attorneys who I'm sure are going to be offering similar kinds of advisory meetings. Okay, how do you contact us if you do want to set it up? You can call, email, or go online to our website. With that, we're going to, Lara has just unmuted herself so that she's back visible to you and me and can talk with us, and she's going to let me know if there are questions in the Q&A.
Okay, we do have a number of questions already in the Q&A, and I anticipate maybe more will come in as we're going through these, which they're welcome to. So one of the early questions we had was from Cynthia, and she asks with respect to the mother in the family. The mother had already given to her 2 sons each 2% of a house. Will tenants in common be any help in passing down the house with the new law?
Well, so if they're all tenants in common, what they probably need to do, well, they only own 2%. I assume that neither of the children live in the house. I'm just going to make that assumption. If neither of them are going to live in the house, and the family home exclusion is not going to apply, if mom wants to kick that up to them owning a full 1/3 of the property, they could then transfer it into a joint tenancy with once they're all there. And actually they could transfer it directly from tenants in common to joint tenancy, which requires it to be in equal shares. So that transfer will automatically transfer it, make each of them a 1/3 owner. And then when mom dies, it will pass to them as original transferors without property tax reassessment. So yeah, I think that transfer into joint tenancy, because they don't own a full 1/3, should be done before February 15th, so that because it isn't going to be an exact same dollar value, they're going to be getting greater value there. So you need to transfer that before February 15th or 16th to make that happen. But that would be the simplest way, since you're already partially there.
Okay, so kind of related questions from Christine. She asks, is it possible to just place the child on the deed today to avoid this tax?
Yes. Again, if you're putting the child on the deed, if you're giving the child the property outright, of course you can do that. But the consequence of doing that is the loss of basis step up at your death. So the child will have this property with your assessed value, but and I'm making an assumption there that it is your personal residence, so you'll be able to transfer it of any value to your child. Again, the child doesn't have to be living there if it's done before February 16th. And if you're not living there, then the current assessed value is under $1 million. So making those assumptions. Once we have that, if you transfer it to your daughter just outright, she will get your assessed value. Property tax won't go up, but you will lose the capital gain basis step up at death, which is a very, very valuable. So you want to make some adjustments there to be able to get most of your cake and eat it too.
Okay, so follow-up clarification from Cynthia with respect to the mother and the 2 sons. One of the sons does live in that house. So with respect to you.
Okay. Well, again, if we're using that technique of the joint tenancy, then that can happen if there's 2 sons then continue to hold it in joint tenancy, and they were this original transferors in the machination that I described before, then one could literally sell his interest to the other one, the one who wants to stay there, and that would not be considered a change of ownership because there is an original transfer or staying on the property.
Okay, and then a follow-up question from Christine related to the same concept. Do we have to do the tenancy in common before a joint tenancy in this type of scenario?
So I really poured over the tax code on this, and I believe, yes, you do. That if you're joint tenants already and you transfer tenants in common, while that's proportional, I think that that may trigger a change of ownership. And at any rate, that I think that the exclusion for this original transfer or is from tenants in common to joint tenancy. And so I would start it out, if you can, as tenants in common and then build it from there.
Okay, and then a kind of a big picture question. This individual said that they keep hearing people talk about inheritance, but isn't this really about any type of parent-child transfer or bequest or even an inter vivos gift?
Exactly.
Right?
Yes, on the advertising for the whole thing was talking about inheritances, but it really applies to any transfer. Doesn't matter if it's at death or during lifetime.
Okay, and a question from Kathleen. She says, if a biological parent predeceases a step parent and step parent inherits in hiats the home or properties, can step parent pass property on to stepson?
Yes, the step parent, stepchild is considered a parent-child relationship. So if you do it before February 15th or by February 15th, that stepchild, step-parent transaction would be qualified under the Prop 58. If you do it later, then it's limited to the family property, because they are still continuing to use the definition of child from Prop 58.
Okay, the next question from Nanette, you answered in the presentation, but just to recap, the question was, is the exclusion under Prop 19 limited to the first 1 million of fair market value? Looking for confirmation.
So yes, so it's the current assessed value plus $1 million. So if your current assessed value is, let's say, $500,000, so 500,000, then you get to transfer, and the home at the time of transfer is worth no more than about $1.5 million, then no reassessment. But if the home at that time is worth $2 million, then you've got an extra 500,000 that's going to be added to the original assessed value. So remember, I said the original assessed value is 500,000. Adding this extra 500,000 on it, the new assessed value of the property will be $1 million. So then I hope that answers.
Okay, here's another question. What happens if a child moves into an inherited personal residence for a while, a few months or a few years, making it hers, and files timely for the homeowner's exception or exemption? Then that child moves out and wants to rent out the property. What happens?
So there's been a lot of speculation. There is no regulations on this. We don't know right now, but most conservative opinions is that child ought to live there maybe 2 years, at least 1 year, at least one full tax year. But it could be 2 years would be a better, safer thing to do. Once we don't know whether if the child gives up that homeowner's exemption and turns it into a rental property, if that will trigger anything. We don't think it will, but we don't know yet.
So when do we anticipate the regulations will be out?
I understand they'll be out, at least something will be out the week after Thanksgiving, the first week or so of December. I actually just heard that from someone else and I didn't verify it. I apologize. But as time goes by, then more and more will come out to amplify anything that they bring out.
Is it possible the assessor won't issue regulations until after February 16th? Is that?
Oh, so no one is thinking that. They're
Okay.
going to have to come up with the rules for how the property. So it's actually the Board of Equalization, which is sort of the governing entity over all of the assessors' offices as far as the law goes. And they're going to need to give guidance to the various county assessors' offices. So I'm sure that they are working very hard through the holidays probably to get all of the rules and regulations so the assessors' offices will know what to do and will be able to process everything correctly as of February 16th.
Okay. All right, here's another question. If a child moves into a parent's vacation home, will they be exempt?
No. I mean, and we're talking about after February 16th, I'm assuming. So if they move into that was not the parent's personal residence, and therefore it does not qualify for the family home exclusion.
Okay, and here's a question from Mary. Is one still allowed to give one's home to one's children? Then if you live for 5 or more years, they maintain ownership after you die. If so, does the property tax remain as it was when the parent was alive?
There's no 5-year rule on property tax. So if you give the children the home, I'm assuming before February 15th, or, if you're giving it to, so here's a question, this sort of popped in my mind, is what if you give it to 2 children and both of them move into the house? Does that count as the family home exclusion? Or what if only one of them moves into the house? Those are the kinds of things the regulations are going to clarify. But in your case, the question had to do with the 5 years, staying there for 5 years. There's no, if you do it before February 15th, there's no requirement that they live there at all, or that how long they keep owning it. Now, there is something called a step transaction. So if you give it to your child and your child then gives it to their child, and so that you can get it to a grandchild, and that happens too fast, it might be collapsed into looking like it was a transfer from you to the grandchild that might not have qualified for an exclusion under Prop 58 and 193. So, or under Prop 19. So I would, but there's no magic 5 years as to needing to hold it that length of time. So just as long as we're not doing it too quick to trigger that step transaction rules.
Okay, here's a question from Skip. He says, if mom were to give half ownership to child, would mom then have to pay the gift tax on that?
Oh, okay. Well, now we're talking a different tax. So yeah, we're leaving property tax for the moment. If mom gifts, let's say the house is worth $1 million, make it simple, and she gives half of it to the child, and if she retains the other half, it is a property. It is I think it is a completed gift for gift tax purposes. Although the property when mom dies will be brought back, the entire thing will be brought back into mom's estate if the son did not pay for it. So you get a basis step up on the entire thing under the joint tenancy rules. If it's not in joint tenancy, tenants in common, I'd have to look at my tax code to confirm that. But, you know, yes, bottom line is you probably do have a tax filing requirement. Remember, though, that estate and gift tax, this is a federal tax, is a unified tax. And under that unified tax, you can give away, under current rules, up to $11.58 million before you actually pay any tax. So if your estate's never going to be over the exclusion amount, then it's merely a tax filing requirement. There's no tax going to be due. And of course, we don't know what that exclusion is going to happen. You know, it could come down to 3.5 million, 5 million, 7 million. You know, nobody knows. And it'll depend. We'll just have to wait and see what the years bring us. Any more, Laura?
Yes, there's a few more. Question from Angela. Can you go over briefly the option of creating a trust with a power of appointment and how that works to mitigate Prop 19 and the step up in basis at the death of the parent? Well, maybe, sorry, before you answer that, another question from a different Angela. Can you just briefly describe what the step up is?
Oh, okay, sure. So when you die, anything you own or control is considered part of your taxable estate for estate tax purposes. Remember, I just said gift and estate tax is an exclusion of 11.58 million. Okay, so it's part of your taxable estate, and because it's part of your estate, it is subject, and I use that word intentionally, subject to estate tax, even though your estate may never get over that exclusion amount of 11.58 million. But because it is subject to estate tax, it gets something called a basis adjustment at your death to avoid a double taxation of it, both estate tax and capital gain. And the basis is what you remember. The basis is you start with what you purchased something, the amount you purchased it for, irregardless if you paid cash or a loan for it, plus any improvements you made, minus any depreciation that you've taken. So you figure out what this cost basis is for capital gain. Capital gain is the difference between the sales price and your cost basis. That whole appreciation, that whole capital gain is part of your estate for estate tax purposes. Because it's subject to estate tax, if then it's subject to also capital gains tax to the beneficiary, in essence, they've taxed that same appreciation twice. Once is estate tax and once is capital gain. So in order to avoid that, they move the basis, that basis that you would have paid capital gain on, is adjusted or stepped up. And we all hope it's going to step up, but it's really an adjustment to the date of death value. And this is on everything that carries appreciation. So it could be real estate, it could be stock that you own that has highly appreciated since you bought it. It also is, as I tried to point out, it's adjusted to the date of death value. So it is feasible that the basis in that property or that asset could go down if the property has depreciated since you acquired it. So I hope that explains what basis is and the step up that I'm talking about. It's the redetermination of what's the basis in the property after you die, moving it from what it was before you died to the date of death value after you die. Okay, and then that related question, more in detail, can you go over
briefly that option of creating a trust with a power of appointment and how that works to mitigate Prop 19 and the step up in basis at the death of the parent.
Okay, so a while ago I said that everything is, that what's in your estate is what you own when you die and what you control. And so if you give something away, let's put it into an irrevocable trust, you give it to your children in that trust, you don't retain any power over that other than this power of appointment. A power of appointment is the power that you reserve to yourself to change the beneficiaries. If you retain that kind of power for income tax and estate tax purposes, it's considered too much control. And because it is the property that is subject to that reserved power of appointment is pulled back for estate tax purposes only, not for property tax. Estate tax is pulled back into your taxable estate, subject to that $11.58 million limit, exclusion limit. And because it's part of your estate, you get this basis step up on the property because you kept that control. It's a control feature that we use for getting our basis adjustment, but not getting it deemed to be a change of ownership for property tax. As an elder law attorney, I also do a lot of Medi-Cal planning. We use these powers of appointments in trusts very frequently for Medi-Cal planning as well.
Okay, and a question from Jeff. He says, if I'm added as a joint ownership with my parents for their residential property, does that then limit their options for reverse mortgages or refinancing down the road?
Really good question, Jeff. And I should have put that on my other problems. That comes under the parent control kind of thing. So if parents do not own the whole property, and you're on title and you're under, I think it's 60 years old now, they will not be able to get a reverse mortgage. If you're over 60, all of you can get a reverse mortgage, but the amount that you can get will be less because they'll be basing it on the youngest age, I think. But that will be something to consider if you're going to need to get a reverse mortgage on the property.
Okay, and we have a couple of questions where the person asking has their home already in a trust. And this one in particular says, we have a single family home in Santa Clara. The homes around us are selling for $1.9 million. We own our home, it's in our trust, and our trust was just updated. Our two sons will inherit the house upon our death through the trust. What should we do now to minimize their tax?
Okay, good question. So the trust that you're talking about is a revocable living trust. That trust has no protection at all for anything. The property in it, other than from probate at your death. So the property in it is going to, you can transfer that at your death to the one child, and they would still be able to maybe qualify for that family home exclusion. But since your property is worth $1.9 million, and did she say what the assessed value is on the property? I missed that. Okay, let's assume the property assessed value is $300,000. So it's got a $1.6 million increase in value. If any of the children live there, then it doesn't matter that it's going from your living trust to your child. They will then have a new assessed value of the $300,000 you had originally. They'll get to exclude 1.3. So I said the property was, did I say 1.6? If it's worth 1.6 now, then they'll get another 3. So it looks like, if I calculate this on top of my head, it looks like their assessed value will become $600,000 in the property, and the property taxes will basically double. But you'll be able to get, it won't go up to the property tax, what the property tax would be on a $1.6 million property.
So that's what would happen if they do nothing. But if they were to do something,
If they do something now, then before the tax, the February 15th, we probably, in your case, since you're using trusts, and it depends on what the property is, well, I think that a lot of answers are going to be using the irrevocable trust that I mentioned before with that retained power of appointments. So, you know, it is one of the difficulties that we're looking at is whether if you as the parent continue to have the unrestricted right to live in the house, do you have the sole present interest in it? And was there a change of ownership at all at the time, you know, prior to February 15th? So I think that we're going to have some situations where parents just decide, you know, they aren't willing to give up or to pay or anything like that for ownership and use of their own house. And they'll probably end up having to decide that the kids are just going to pay more tax or sell the house. You know, nothing in this it affects the family if the house is going to be sold anyway. I've got clients up in Los Angeles Hills that are holding on to the house so that when mom dies, they get the basis step up, and then they're going to sell the house and split the money. That's what the majority of families do, unless we're dealing with some kind of properties that are sort of a family business or something like that. Most people don't, most of the kids don't keep the house. They sell and take the funds and use them for other things, especially if you have more than one child. So that's very likely what will happen in your family.
Okay. So we still do have more questions coming in. There's about a dozen still right now. A question from Lynn is, if the parent transfers to a child and the child already has a revocable trust in her name with her spouse, with the child's spouse, how can the parent make the transfer to their child only and not to the spouse?
Well, in California, everyone knows that we're a community property state. But there are 3 exceptions from community property treatment of assets that are acquired during. So it's assets that you had before you got married, or assets that are acquired during marriage by inheritance or gift. So when you give that house to your daughter and you give it to her in her sole name, my recommendation is that it is her separate property when she gets it, but she should put it into a separate property trust to just make sure that it stays that way and that she isn't contributing community property assets to the property. It can get murky in there. And that's what family law attorneys are all about. If there's a divorce, figuring that out. But it is her separate property when she receives it. It's her responsibility to make sure she keeps it as separate property. Now, instead of giving it to her outright, why don't you consider giving it to her in trust, maybe for her lifetime, and it never becomes hers to transfer in and become part of community property or allegations of community property asset for divorce purposes. That's a safer way to do it. Just don't give it to her. Don't depend on her to keep it separate. But yet let her have the benefit of the ownership by getting being able to be supported off the trust you set up for her.
Okay, here's another question. With respect to the tenancy in common and then moving over to joint tenancy, only the transfer to tenancy in common has to occur by February 15th. Is that right?
Yes.
Other statutes govern the later exclusions. Is that right?
Yes, exactly right.
Okay. All right. And then a couple questions from Bridget. She asked,
Let me back up. I want to make sure that the proportional interests into the tenants in common are the same, it's equal. If you give your kids, as the prior question was, just 2% of the property, and then later you transfer in tenants in common or joint tenancy where everybody has a 1/3 equal interest, that's going to be deemed another transfer. So you got to have the right proportion from the get-go into the tenants in common. But once you do that, then the other transfers do not trigger a change of ownership.
okay. A couple questions from Bridget. She asks, is it possible that a future proposition, we addressed this at the very beginning, but partly, could undo any of the exclusions or solutions presented today? So that's hard to foresee.
Okay, there's a lot of crystal ball work here. So I doubt it. I would very, very seriously doubt it, that everything we're doing now would be what was done under a prior law, and therefore it would be excluded. So this does raise an issue for a lot of you out there. If you are, if you say you and your spouse had an AB trust, your spouse died, and part of the property, the real estate, went into the B side of the trust, that property might become a problem for your child when they inherit it at the end of the term of the B trust. So one of the thoughts off of an example I saw in the Board of Equalization information is that you might sell the property out of the B trust to the child now. And of course the B trust will recognize any capital gain on that sale over the value that when it went into the B trust. But that would get the property out of the trust now before Prop 15, before February 15, and you'll still have assets in the B trust. So assuming that the B trust doesn't have any prohibitions about it, I think that might be a clever resolution to property that's in that B trust.
Okay, and another question from Bridget, the definition of principal personal residence. How is it defined for this?
Well, it's the property that would qualify for the homeowner's exclusion. So, or I think there's a veterans exclusion as well, but it means the property that you actually occupy. And so I didn't look up the exact definition of it, but the Prop 19 text references that they use family home, primary personal residence, all of those kind of things. They all mean the same thing. It's a place that you occupy and dwell in as your home, primarily. If you've got two homes, you got to pick one, and it's generally the one that you spend most of your time in.
Okay, a question from Jessica. This is a good question. Do mortgage companies allow the type of title transfers you're suggesting?
Good.
Will we have an outstanding mortgage on our properties?
Yeah, so if you have a mortgage on your property, there may be a problem in that the mortgage, the loan documents have something called a due on sale, or actually it's a due on transfer. The due is DUE. So the loan becomes due if you transfer the property. So we are going to need to look at those documents. It may be that we advise the, and it could also affect title on the property, title insurance, I mean, on the property. So we probably are going to want to get waivers from the lender, maybe notify the title insurance company about these things so that if there is a mortgage on it, that we're not violating the due on sale / transfer clause.
That's another piece of documentation we'd request from.
Yeah. Well, and it might not be a problem. It might be that you'd like to refinance now anyway, because the interest rates are so low. But, you know, so it might be an opportunity to do that if you can still qualify for a loan. And again, you might get a reverse mortgage instead. So, you know, this is a head scratcher, and we need to take every case by case.
Okay, Esther asks, she says, I have 2 rental properties, neither of which my children reside. If transfer rental property to them before February 15th, will the rental property be reassessed for tax purposes if they do not reside there?
No.
What about after February 15th?
Before February 15th, assuming that the total assessed value of the 2 properties does not exceed your $1 million exclusion on the transfer of your non-personal residence exclusion. So I'm going to assume that the combined, that they do not exceed that. It's not their fair market value, it is the current assessed value. So you combine those, and if those are not more than the $1 million, then you're fine before February 15th. After February 15th, there's complete reassessment on those property transfers.
Even though there's potentially 3 properties in question here, 2 rental properties and the property Esther lives in.
Oh, okay. So the rental properties are going to get reassessed if you, so the house you live in does not have to be part of that $1 million. Let's talk about the before February 15th transfers. It can be of any value. It can be, so you're unlimited in the transfer of your personal residence to your children before February 15th. After February 15th, it's going to be limited to that family home exclusion. And again, that can be, that transfer can be at death, as they sort of advertised in the advertising for the act, but it can also be during lifetime. So you could give away the house to the kids after that, but it's going to be only available if the child that you're giving it to actually resides there as well, or moves into it within a year and claims that homeowner's exemption.
Okay.
So I hope that answered.
All right, we have a question from Virginia, hypothetical, or their family scenario here. They have the adult daughter living in a home owned by elderly parents, and the daughter will continue to live in that home. It's a second home for the parents. The current assessed value is $750,000. The current market value is $3.5 million. And Virginia asks, how should we go about thinking about maintaining the step-up basis and maintaining the current tax basis? What tools? What strategies?
Well, first off, this cries out for getting done before February 15th. So then the question becomes, what are the other issues involved here, and including capital gain, the desire to get the capital gain basis step up at death. And that only happens at death. If you transfer it during lifetime, you don't get the basis step up. You get the basis that the transferor had, your parents had. So if it goes from parents to children during lifetime without any reserved control or interest in the property, then you're going to get the basis as your parents had it, which means that if you sell the property, you're going to have all that capital gain. So we want to be able to get that basis step up if possible. $3.5 million house with an assessed value of $750,000. If that is your parents' house and you continue to live there after your parents die and you claim that homeowner's exemption, then you're going to have an an exclusion from reassessment of $1,750,000. That's going to leave another $1,750,000 or so. I think that you're going to have a property tax of about $2.5 million. Off the top of my head, I'm just rounding some numbers here, but that to stop that from happening, you're going to want to transfer that some way, somehow, before they die, or plan that you're going to sell it after they die. I mean, again, this does not mean that you need to keep the property. Just because you can keep the assessed value by doing all these things now doesn't mean you should or will want to.
Okay, so Virginia also clarified in that scenario, the parents or the owners do not actually need to maintain any control over the property. They don't. I think your scenario addresses that. They don't. There's not like an issue within their family that the parents needed to maintain control over the property.
Only if we want to get that capital gain basis step up. Okay. We need to have, and it's not control exactly over the property. It's enough control that for estate tax purposes, they're deemed to be the owner. That doesn't mean they really control it.
Okay. All right. A question from Michael with respect to the LLC scenario you talked about. After Michael's death, he has 2 children and their share becomes 50-50. Can I use a grandchild tiny share of 1% to keep his 2 children's individual shares below 50% after his death? So
we're talking I think I got lost in here. We're talking the LLC example,
right?
So he's going to give instead of, so if he's got 2 children, and they're
right,
going.
Well, first of all, the problem is if it's over 50%, right?
Okay.
So 2 children could own it 50-50.
Just as well, there's 2 rules. One is, have you transferred more than 50%? So assuming that you haven't, then we haven't had that that original owner transfer of more than 50%, which could cause a change of ownership. If we're only talking about the one that is the control, and no one, after all of your transfers, still no one has more than 50%, then you're fine. And you could give it to a grandchild. Now that transfer to the grandchild is if it's a share in the property, in the business or in the LLC, that is not reassessable while it stays in there, I think. I would have to review the codes on this.
Okay, but the 50%, so 50% is vastly different than 50.001%, right?
Right. For
50% is fine.
50% is fine. No one has more than 50%. No one is deemed to have control.
Okay. All right. A couple questions from Min. She asks, if a property is currently being held in joint tenancy between mom and son as joint tenant, and mom wants her 50% to go to her daughter, and daughter is sole beneficiary of trust, is daughter protected upon mom's death, or would the inheritance be considered a change of ownership? To add to this question, should mom gift her 50% outright to daughter now so that daughter and son hold joint tenancy together?
Okay, so we're in joint tenancy now with son. That means 50-50, and that the property then, and you said that your 50% is going.
Mom wants her 50% to go to daughter.
Okay, well, first off, you have to sever the joint tenancy in order for daughter to get that, or somehow substitute you could transfer your half to daughter you and son could transfer your half to daughter before February 15th. You would get a parent-to-child transfer exclusion. You don't have to depend on the joint tenancy rules. And you don't have to have them going back into joint tenants. So maybe you sever the joint tenancy, you give your daughter 50% as a tenant in common with your son. They then can they can then continue to hold it in tenants in common. When you die, they already own it. Your daughter owns half, your son owns half. And if they then want to, or at some point, one wants to buy the other one out, they could transfer it into joint tenancy with both of them being deemed an original transfer, or at that point, one could buy out the other. The remaining one is an original transfer, and therefore the property is not deemed to change ownership at that point. That's off the top of my head. Again, this is a little bit of a scratcher, and that's why I'm saying these are complex. You guys are giving me some complex scenarios, so good for you.
All right, so here's potentially another one. If a parent couple attempts to do a tenancy in common, then to joint tenancy strategy with one child, then should the transfer be tenancy in common as 1/3, 1/3, 1/3 for each person? So father, mother, and child.
Yes.
The 1/3 under joint would be 1/3 owner under joint tenancy. Does that still work for preserving both the Prop 13 basis and stepped up basis upon death of the last parent?
Yes. So the one thing that I would consider here, and I actually would have to think through this a lot more, is community property. So a while ago, I was explaining the basis step-up rules. And I said, whatever the decedent owns is part of their taxable estate, and so it gets this basis step-up. What I didn't explain is that in the Internal Revenue Code, there is an exclusion, there's a benefit if the property is owned as community property. And there's 9 community property states. The other states don't qualify. So if you're in one of the 9 community property states and the property is community property, then not only the deceased spouses, half of the property gets this basis adjustment or step up at death, but so does the surviving spouses, half of the community property. So instead of just half of it going up, you get both halves going up. So you've got a new basis in the property. So in your scenario, what comes to mind is if we have, and also in California, property that is held in joint tenancy between husband and wife is presumed to be community property. So my question, and that I'd have to ponder and maybe look at some codes on, is if mom and dad and son are all on as joint tenants, can we keep mom and dad's joint tenancy interests as community property as between them? I think the answer is yes, and that is good, because you want that double basis, we call it a double basis step up, at the first of the parent's death. Although at the first of the parent's death, that parent's basically 1/3 interest will go equally to the surviving spouse and the child to keep that joint tenancy right of survivorship and equal interests. Oh, Laura, probably lost track of the actual first base question there. I got off talking on a tangent.
I
So
think you were addressing it because they're really, their goal is, does that still work for preserving both the Prop 13 basis and the stepped up basis upon death of last parent?
yeah, well, and certainly if okay, so one parent dies, the property is now 50-50 between the surviving parent and the child. When the surviving parent dies, his or her half gets a basis step up. Well, if they created the joint tenancy initially and the child never contributed anything there, then I think Revenue Code 2040 comes in to bring the whole thing into the parent's estate. Again, I almost have to chart this, but I think that that's what would happen. I think you're going to get a full basis step up on the whole property, as long as the child didn't contribute to the purchase or of the property. They didn't contribute anything to the joint tenancy. It all came from parents.
Yeah, that sounds like a good solution if they. All right. The last question we have is somewhat vague, but it says we have 2 rental properties. We have 2 college kids. What is the best solution to deal with Prop 19?
So how about you've got 2 properties and 2 college kids.
2 rental properties.
2 rental property. Well, the question is, do you want to give up? Do you want to give up ownership of those properties at this point? Your kids are only in college, and maybe you want to sell them and move on to other things. But let's say you're willing to do that. Again, think about all of the ramifications of this to yourselves. Are you going to need those properties later? Do you know, etc. So if we're going to do that and the kids are in college, I'd probably use irrevocable trusts in this case, because the kids are younger. You don't know what's gonna happen to them. You probably want to protect the property for them, and you might be able to do it into that kind of trust that I had an example where the parent retained, the kids and the parents could go on and retain as what we call present beneficiaries. And so the trustee could sprinkle the income from the rental among any of them. The trustee elects to sprinkle it out to parents or parents, and at least for now, maybe at some other point to the kids. But as long as that's happened and you've done it into this trust before February 15th, then the portion that goes to the kids is considered under the Prop 58. Again, assuming that you're you don't exceed the $1 million of exclusion on assessed value transfer of non-personal residence properties. All of those things, got a lot of assumptions there, but if all of that's true, then I think that the irrevocable trust with the sprinkling may be the best way out of that. Again, you don't know what's going to happen in the future. You aren't saying, are you intending that one child have one property versus another? Maybe we think about 2 different trusts, one for each of the properties. So I think there's a lot of questions yet to be answered in that case. But whatever you do, if you're going to do it, you need to do it before February 15th.
All right, that's the bottom line on almost everything here. That's our last question today. Turning it back to you.
Oh, that was the last question.
Yes, that was our last question.
Well, my goodness, thank you to the 47 participants who are still on the webinar with us. We appreciate you hanging in there. I hope I've answered some of your questions. You know, you might want to take advantage of, you know, if you don't think you need that initial consultation, paying me $450 for that, and you just want to hire us to implement these. If you're not going to go back to your other attorney, or you don't have an attorney, or you're already our client, you can set up a design meeting, which you know, will mean that you're hiring us to do work. But I would encourage you to maybe start with that $450 consultation and see where we go from there. I actually had a meeting with one of my clients yesterday. Actually, two of the clients. Was it both yesterday? Maybe it was the day before and then yesterday. And at least in one case, the parents decided, heck with it. Their kids will just sell the property when they die. This is all too complicated. The only one in the family might be a granddaughter who would want it, and it was just too complicated. So so they're not going to do anything. The other one yesterday, we can help with one property. The other property that is where the daughter lives, that one we might do this joint tenancy on. So we will see. So it's not going to be a perfect answer. You might choose to do nothing, or do nothing for some properties and do something with the other property.
Right.
Anyway, thanks for doing all the questions, Lara. That was really good. And again, if anyone out there wants to set up the appointment, the screen has our contact info. I think that my office is preparing to send out the slides. If they haven't already, if you contact us, we will email them to you so you can have the slides. I apologize that we didn't figure out how to give them to you to be able to download on your own. We're still figuring out this hosting of webinars process. So thank you all.
All right.
For bearing with me.
The slides have been sent.
Pardon, Lara?
Lane just says the slides have been sent.
Oh,
But if you receive it, then please call our office.
okay, good. Thank you, Langia. So with that, I look forward to chatting with some of you person to person. Again, if you have an attorney and you want your attorney to be on that informational meeting, 45-minute call, that's fine with me. So, you know, I'm just going to try to brainstorm together with your attorney about what some good solutions are for you. And thank you again, Lara. Thank you, Langia, for your assistance in this. I apologize to everyone for my sticky fingers and how I'm controlling the slides, but you know, I'll get better. I can learn new tricks. And with that, I'm just going to say goodbye, everyone, and have a really happy Thanksgiving. If I don't talk to you, oh, speaking of Thanksgiving, I've just canceled all of, my husband and I are not going to be spending time with Laura and her family and the other younger members of the family that are meeting. So we're going to stay isolated, which means that I think that I'll take these phone calls over the holidays, not Thanksgiving, but probably Wednesday and Friday, maybe even some on Saturday. And we can set them up as a phone call or a Zoom call. So if you have a family gathering during that time and you want to get on calendar, your other attorney probably doesn't want to be on at that time, but so keep that in mind. But we're going to set aside time and try to schedule these in very heavily so we can start talking about what needs to be done and start planning for our workload if we're going to do the work. So with that, everyone, again, happy Thanksgiving, Happy holidays if I don't talk to you before the Christmas, Hanukkah holidays. Okay,
Bye-bye.
thank you. Bye-bye now. Let me see how I do this. Stop that. Stop